be best understood and learned through little ones by Mahatma Gandhi. Honorable Chief Guest Advocate Sherry J. Thomas sir, respected Jeffrey Johnson sir, Head of the Department of Commerce Self-Financing, teachers and my dear friends, a warm good morning to one and all present here. Today we'll begin the webinar with the blessings of God. So we'll observe 1 minute as silent prayer. Today's webinar is based on the topic legal provisions with respect to child labor, which will be headed by your chief guest advocate Sherry J. Thomas sir. Sherry J. Thomas sir studied at St. Albert's College, Maharaja's College, and also acquired a postgraduate degree in law from Mahatma Gandhi University. Also studied cyber law from National University of Legal Studies, former reporter and translator of High Court of Kerala, owner of Sherry Legal Associates. Now let me welcome Alina Ambrose of BCom with the Computer Application, second year student, to deliver the welcome address. Alina, please.
Good morning. Today I take this opportunity to address the gathering. First and foremost, I take this opportunity to welcome our chief guest for the day, Advocate Sherry J. Thomas, who is the practicing lawyer who stands for social and legal rights with an intent to promote law and justice. He is also editor and publisher of the first legal blog in Malayalam, Niyamadharshini. He also practiced as an official translator in High Court of Kerala. He is a previous student of St. Albert's College also. He completed bachelor's degree in political science and government from Maharaja's College. He had taken LLB from Cochin University of Science and Technology. He also have a postgraduate diploma in cyber law. He is the director board member of Maradu Service Cooperative Bank. Once again, it is with great illusion I welcome you, sir, to this prestigious occasion. Now, I would like to welcome our Jeffrey sir, HOD of Commerce Department, whose guidance has helped in our curriculum and co-curriculum activity. Welcome you, sir. I would also like to welcome our teachers to this occasion, who are the strong pillars of this institution. Last but not the least, I welcome all my dear friends to this auspicious occasion. Thank you.
Yeah, is it over to me?
Sir, start him.
All right.
Okay.
Respected Jeffrey sir and dear students and other friends. Obviously, today is a day in which the entire world is acting against child labor. And at the outset, I extend my felicitation to the organizers to chart a program on specifically on this apt day. You know, there is no dearth of any law in India. India is the biggest, having biggest democratic constitution, the biggest democratic country in the world. Right from 1947, we are following the principles of freedom and democracy. The Constitution of India was constituted after deliberations of 2 years, 11 months and more. That means people from different walks of life, including the parliamentarians, they were able to deliver and express their views on the laws of the land. That is what I said. There is no dearth or paucity of any kind of legislations in India. But the question is whether it is properly implemented. And same is the situation when we talk about children and child labor. I will take you to the worldwide situation and then I will come to the legislations in India. If you just search in Google about child labor, you will get the definitions of child labor and about children, especially by the ILO, International Labor Organization. It specifies 4 things which affects or what can be termed as child labor. We can term it as any kind of work. I'm talking about in larger perspective, as far as ILO is concerned. Any kind of work that mentally, physically, socially, and morally. So there are 4 ingredients. Any kind of work that can affect a child mentally, physically, socially, and morally. Morally may be a new term for us as far as in some terms are concerned. And these 4 ingredients, if it causes harmful to the children, or if it can be treated as dangerous to children, then we will call it as child labor. So we must bear in mind that even a moral dangerous situation, even a situation which can be termed as harmful in the sense of morality, that can also be treated as a child labor as per the definition of, as per the international definition given by International Labor Organization, ILO. Mentally, physically, socially, and morally. Any kind of work that causes a situation of dangerous nature or harmful nature to the children. It's the reason, it's the clear-cut definition in international level for a child labor. And obviously, you'll be knowing when we connect with the 2011 census, when we come to India, 10.1 million of child laborers are there in India, 10.1 millions. And among that, 5.6 million are boys and 4.5 million are girls. That is the scenario in India. And you might be remembering by going through the legislations or any of the readings, the national policy on children in India, it came into existence in 1987. Even prior to that, there were legislations. We are not denying it. But a policy was taken in 1987, which says interfering with their schooling. It says wherever children are depriving of schooling, wherever there is interference in the school life of children, it also comes under the purview of child labor or any kind of deprivation of rights of children. The UN, the ILO, there were 2 conventions in ILO regarding the child labor. That is, you will get it in Google. That is Convention number 138 and Convention number 182. 138 says of minimum age. The International Labor Organization and the signatory countries to that organization on international level, they have accepted a minimum age to a child in which a child to be exposed to work. As per the Indian law, it is 14 years. And the Convention number 182, it says, it defines and it prescribes worst forms of child labor. These all are history. When we talk about the child labor in India, we can see the system of bonded labors, bonded child labor. After having a glimpse on that history, will come to the legislations in India. So, as I at the outset I said, in international level, there are 4 ingredients it can be treated and act as a child labor, which comes any work that mentally, physically, socially, and morally can be termed as dangerous and harmful to the children. It can be defined as a child labor. As far as in India is concerned, we will be getting the details in I will cite an example. It's an event which happened in 1977. The National Human Rights Commission conducted a surprise inspection in some of the factories in Tamil Nadu. It found 53 child laborers which were sold to the owners of that premises for rupees 1 lakh to 2.5 lakhs. Children were sold for rupees 1 lakh to 2.5 lakhs by their parents to the owners of the factories and other mines, etc. and they were forced to work 12 to 14 hours. Interestingly, the wages which was given to them is rupees 2 or 3 per day. They were working in diamond industries. Even now, we can see in diamond industries, fireworks industries, silk manufacturing units, carpet weaving units, domestic laborers. They are working as domestic labor. That is present situation. But in 1977, I introduced you about a surprise visit by the National Human Rights Commission itself. So that was the scenario in which the country was facing during those years. Thereafter, we are coming to the legislations in India. I'll try to share some of the legislations. One is Factories Act 1948, then Mines Act 1952, then Child Labor Prohibition Act 1986. Later, it was amended also in 2005. Also, it is amended. Amendment was in Juvenile Justice Act. Then Juvenile Justice Care and Protection of Children Act 2000. Its latest amendment in 2015. Then Right of Children to Free and Compulsory Education. It came in 2009. These are the pieces of legislations which are at present in force in India against the child labor. So I am putting the way that in international level, the child labor has given a wide definition. When it comes to India, we are pinpointing several legislations, including the Fundamental Right Article 24. You can get it in Google also. Article 24 says, no children below the age of 14 shall be employed in any hazardous industries. It's a fundamental right. Before stating about the legislations, I will say about the difference between a fundamental right and an ordinary right. As far as Factories Act is concerned, Mines Act concerned, Child Labor Prohibition Act, etc. Apart from that, the provisions of fundamental right can stand in a little bit higher status. A fundamental right starts from the Article 12 to 32 of the Constitution. The Article 24 of the Constitution deals with the rights against child labor, which comes under the fundamental right. The difference between the fundamental right and other ordinary rights is that the state is bound to protect the citizen and to provide the rights which are enshrined in the part 3 that is called fundamental rights. Whereas on the other rights, it is the duty of the petitioner or the victim or any other proponent. He has to claim it before the court of law and get an order. Especially it can be against a government order, against any other order, private wrong, they have to go to civil court. But as far as the fundamental rights are concerned, it is the bounden duty of the state, can be through the police or through any other government machinery, to protect the interest of the citizens, as well as to non-citizens, some fundamental rights are extended. So Article 24, it's a part of fundamental right, and it helps the children and the public to prevent the child labor, as we are discussing. Then the second aspect is Article 21A. Amendment came recently, not so recently, a couple of years back. If somebody is asking you that the right to education is a fundamental right, I mentioned the difference between fundamental right and an ordinary right. So acting against doing protection against child labor is a fundamental right. We have already talked about it. The question is, you are having the right to education. It is a determinable right. You have the right, but whether is it a fundamental right? Prior to the institution of amendment in Article 21A, it came by way of certain precedents. Unnikrishnan case, several other cases. The Supreme Court and High Court said to get education, to proper education, it is a fundamental right of the child. So somebody is bound to provide that proper education. It is a duty of the state as well as the parents. And there comes the right of children, free and compulsory education in 2009. So it's as part of it. But so two things we have to bear in mind while discussing the legislations which helps to prevent the child labor. Two of the things fall under the fundamental rights, two provisions, Article 24 and Article 21A. Now we'll discuss the other legislations. I tried to share a portion. Mindset. Is it in the screen? Mindset.
Yes, sir.
Okay. As we discussed, there are a couple of legislations which are helpful to prevent the child labor. And Mines Act 1952 is one of them. You will be thinking, now where are the children in mines? In Kerala, it's not an issue. But there are several other places in India, due to the intervention of these legislations and other NGOs. As of now, in mines, children may not be working. But this is a legislation which is enacted in 1952. It prohibits the employment of children below 18 years of age in a mine. And mining being the most dangerous occupation, which is in the past has led to many major accidents, taking life of children is completely banned for them. This is one aspect. And the another piece of legislation is Factories Act 1948. You know, in earlier days, these were the places in which children were given as bond. We can call it as bonded labor, child bonded labor. The parents will sell the children for a particular price, and they have to work there for years. And the Factories Act also prohibits the employment of children below the age of 14 years in any factory. This law also placed rules on who, when, and how. That's a specific point. Who, when, and how. Pre-adults of age 15 to 18 can be employed. That is, in certain lighter employments. Certain items are listed as hazardous in this act itself, and there are non-hazardous in which the children of 15 to 18 can be employed. That's also gained significance as far as this legislation is concerned. Then, right of children to free and compulsory education. This is one of the revolutionary legislation in India. The state provides free education to all children from 6 to 14. Suppose a parent says, no, I don't want to send my children to school. I want to send him to support my family. That's not possible as per this legislation. And it mandates 25% of seats in every school to be allocated for children from disadvantaged groups and physically challenged children. These disadvantaged groups comes under BPL category, and certain other categories are charted in it. So this provides, this is, we have to read together with Article 21A. What does Article 21A says? 21A says right to education is a fundamental right. Article 21, briefly, we can sum up it as right to life. Article 21. Article 21 is one of the most used provisions of Constitution of India. Its definition is elaborate. Right to life means it's not mere animal existence. It's not mere animal existence. It means right to live with dignity, right to water. You cannot see a right to water in Constitution. You cannot see a right to air in Constitution. But these all are compiled in Article 21 because it terms right to life. Similarly, right to education is also incorporated. Even though there is no specific wording of right to education, the courts of our land has, through precedents, stated that the education is also a fundamental right. Thereafter, a specific enactment was there, that is Article 21A, which says right to education is a fundamental right. And the Article and the Act 2009, right to education of free and compulsory education, Act 2009, it has to be read along with Article 21A. So this act is coupled with the power of a fundamental right. Then comes the Juvenile Justice Act and Child Labor Prohibition Act. I will share that portion also. I think that slide is missing. And then Juvenile Child Labor Prohibition Act says children below 14, in no circumstances they are allowed to do any kind of work, except in helping own family in non-hazardous occupations. except helping their family itself in non-hazardous occupations. Then the children from 14 to 18, it can be termed as adolescent, the age of adolescence. And these adolescent children can be employed in certain listed non-hazardous work. I'll mention those works also. So there is no blanket ban, but certain exceptions are given, and that comes the hazardous occupations that is defined in Part 3 of the Child Labor Prohibition Act. It can be termed as prohibition of employment of children in certain occupations and processes. The schedule gives a list of hazardous occupations, that is A and B lists are given. I will just go through it, just have a glimpse on it. No children shall be employed or permitted to work in any of the following occupations, in which I am going to read. You may listen. Transport of passengers, goods or mails by railways. Then comes clearing of ash pit or building operations, so on so. Then working in a catering establishment of railway station, etc. Then work relating to the construction of railway station, so on so. Then port authority, work relating to port authority. Then work relating to selling of crackers and fireworks in shops with temporary licenses. Then slaughterhouses, working in slaughterhouses, automobile workshops and garages. Then handling of taxis, handloom and powerloom industries, mines, already we discussed, and plastic units and other fiber units. These comes under Part A. And Part B says, no children, I'm talking about the Child Labor Prohibition Act, various list in which children can be allowed, shall be prevented. Part B says, no child shall be employed or permitted to work in any of the following, so and so, which comes one, bead making, then carpet weaving, then cement manufacture, including bagging of cement, cloth printing, dyeing, weaving, etc. Manufacturing of matches, explosive and fireworks. Then soap manufacturing, wool cleaning, building and construction industry, manufacture of slate pencils, then manufacturing process of toxic metals, etc. Then it is listed about more than 50, altogether 51 items were listed in Part B, which includes stone breaking process, tobacco processing, tire making. It comes so. So 51 listed numbers are listed there. So what I'm trying to mention before you is that the Child Labor Prohibition Act provides certain works which the children shall not be engaged in. And this is the day in which June 12th is the day in which these legislations we have to check whether these are properly implemented. You may not be find any child in factories or mines during these days, but you can find children in hotels, in restaurants, in weaving units, in firework units, and in diamond industry, carpet weaving, etc. You can find children there. Now, even nowadays, if you go to a hotel, you can find the other state children who are doing the cleaning works there. So clear, obviously, it comes under the banned works in this Child Labor Prohibition Act. So that's that aspect. Then the most commonly used provisions of law in this aspect is Juvenile Justice, Care and Protection of Children Act. There are two types of things we have to bear in mind. Some offences are cognizable. The portion which we are now going to discuss, JJ Act, Juvenile Justice Act, you might have heard about child welfare committees. These acts and provisions are usually reported in newspapers in all recent events. You might have come across a WhatsApp clip and thereafter a newspaper report stating that even a father punishing a children who is not sound, a disabled child, he's beating him, and that video has been spread. That video has been taken by the mother itself, and she has spread that video in Ernakulam itself, in Kochi itself, and the hub of the commercial activities. We are claiming that, and in that area this happened, and the police finally registered a case against that parent, that father, and those aspects come under the provisions of JJ Act also, because corporeal punishment to a children, even as teacher patting a child with a stick, Even a teacher doing any kind of corporal punishment to a child, a student, that can also come under the provisions of JJ Act if it is taken so. I'll take to it now, sir. So the provisions in JJ Act also to be very familiar to all of us in recent days. I'll try to share that portion. And the Child Welfare Committee, and we will call the children who is committing offense or who is undergone child labor or any other being a victim. Those children are defined in this act. A child who is in conflict with law will call him as, will produce him before the juvenile justice court, and will not call him as accused. Usually those who are culprits in a case will be calling as accused. But as far as children is concerned, we will call it as child in conflict with law. And that's not our subject. And this is Child Welfare Committee. Suppose in recent days, if you are finding any children are exposed to the labor, child labor, and you are thinking that, oh, this is against the provisions of child labor, then you can approach the Child Welfare Committee. Suppose if you don't want to be directly involved in the issue, but you want to save the child, then you can seek the assistance of Child Welfare Committee. There are certain procedures for Child Welfare Committee, and that is enshrined in the amendment also. That is, we can call that act shortly as JJ Act. And it defines the powers and responsibility of the board in the protection of the child, and mandatory reporting. That's one of the aspects in which the institutions are also to be, most of the institutions are unaware sometimes. Suppose if an offense is committed in a school wherein juvenile are there, children are there, and the teacher or the person who is in charge of the school is not reporting it for the sake of their school, or just settled it, but the matter was not settled and it came out through any way, you assume it. In that event, it is an offense. The person who failed to report the offense has to face the penalty. He has to be cited as an accused as part of the provisions of mandatory reporting in the JJ Act. Then the provision comes, these are the sections which you can go through it. These are the provisions, sections which provide punishment for certain acts against children. Disclosure of identity. You might have noticed that in newspapers, the name of the children will not be revealed. And the photographs of the victim children will not be revealed. That is because Section 74, it's a prohibition against disclosure of identity of the victim. Then 75 is cruelty. That is what I said. Even if a teacher committed any act of very minor act against the child, I mean, just to correct the child, and if that student lodged a petition, if it comes under the terms of cruelty, then the teacher can be an accused in that offense under Section 75 of the JJ Act. Then the specific subject of today is Section 76, employing any child for begging. That's Section 76. Then Section 77, intoxication. 78, using children for child labor or intoxication, etc. Then child employee. Somebody is placed the children as employee, then Section 79 will run. Then comes Section 80. Those are not relevant as far as today's session is concerned. And Section 81, sale of children. That can be useful because in child labor, or sometimes it involves sale. That I said earlier, even the parents would create bond with the owners of these mines and factories in regarding their own children. Then corporal punishment. This is what I said. Section 82 says, if any corporal punishment is occurred, then the liability of the institution is defined in this section. We cannot go scot-free. The institutional head cannot go scot-free, stating that we are obviously we must know that ignorance of law is not an excuse. Ignorantia juris non excusa. Whatever happened, we cannot claim as ignorance. We cannot say that I have no mens rea. Mens rea means guilty mind. But the law, all the legislations in India, it says ignorance of law is not an excuse. So an institutional head cannot say that, oh, I am not aware of the fact that I must report the incident to police or CWC, Child Welfare Committee. It cannot escape from that liability. Then Section 80 for kidnapping, that's already other IPC offenses are also there. Why I am dealing more specifically with this JJ Act, because these are the executive provisions. We have learned a lot of legislations, but there must be some provisions to execute these rights into action. Whenever we are seeing any children are being exposed to these kind of works, the Juvenile Justice Act is a provisions in which they can be booked by the police. And certain offences are bailable, certain are non-bailable, certain are non-cognizable. I'll explain what is non-cognizable and cognizable. Right in the beginning, I said there are fundamental rights and non-fundamental rights. Similarly, some offences which can be termed as cognizable and non-cognizable. Cognizable offence means the offences which police can directly register an FIR and arrest the accused. Non-cognizable offence means police cannot directly interfere. It has to be lodged as a private complaint, or it has to be mooted through Child Welfare Committee. Then only the arrest and proceeding can be done. That is the difference between non-cognizable and cognizable. Probably lighter offence will be treated under the non-cognizable, and serious offence will be always treated as cognizable and non-bailable. Then comes, okay, that's all to deal with JJ Act. Now you may come across with the right of children that I shared a slide earlier, right of children to free and compulsory education. You might have, if any of you is associated with any members of local bodies, Panchayat member, municipal councillor, corporation councillor, etc., you'll be heard from that. Nowadays, okay, after the implementation of this act, they are attending the meetings in schools, in aided schools and in government schools, because the local institutions, local bodies are also having a part for the well-being of the institution, the schools, after the implementation of this act. The meals are giving to the children, free meals, and certain such things are being distributed to children. So the local, that is the significance of the different wings of government to implement these aspects. So at the outset, I said the general provisions of child labor, in the international sense, we can term it as mentally, physically, socially, and morally harmful, dangerous situation. It can be termed as a child labor. Then comes the situation in India. In India, we have a couple of legislations. These legislations are evident on the aspect that whenever there is an offense is there, it can be directly reported to the police. And if some of the offenses, many of the offenses comes under the JJ Act now in recent days, because Mines Act and Factories Act, as far as Kerala is concerned, it is not not often that kind of situations are found. But as far as JJ, the institutional head is also duty bound to report the incident, and even a corporal punishment can result in an accusation. So you must be careful on it. That's not an issue. Then the provisions of the bailable offense, non-bailable offense. Some offenses are very severe in nature. Even you'll be denied of bail. Then some are cognizable and non-cognizable. In some offenses, it depends on the sections inserted in the FIR as per the JJ Act. The police can directly register an FIR, and police can directly institute the proceedings against you. That is in case of cognizable offense. And as far as non-cognizable offense is concerned, it has to move through the CWC, or any private complaint has to be moved. I'll cite an example for it. If somebody is creating any defaming situation statement against you, somebody is defaming you, stating some falsity against you, it is a non-cognizable offense. The police cannot register a case against you, case against that person. But somebody is hitting you with a stick and causing severe injury to you, or somebody such acts are being done, or causing any dangerous act to you. That second thing, the latter one is a cognizable offense, and the previous one, defamation, it's only non-cognizable offense. Police cannot take the action against the defamation, accused in defamation. So that is the difference between a cognizable and non-cognizable offense. So I'm summing up, and in India, we need certain volunteers, because there is no issue with Factories Act. There is no question of application of Mines Act. We can say so. We can say that we are much developed. We are much privileged of having get rid of those situations. But even now, in restaurants, as domestic helps, in certain houses, you can see children working there, maybe from outside state. So domestic workers are there, and hotels and cleaning agents, restaurants, and in all such area, there are a lot of stuff which are being done by these kind of children. Probably they may not be getting, there may not be any kind of bonded labor, but maybe they are doing with their own will for the sake of their family. But the effect says, if they are below 14, Even if they are above 14, there are certain listed items in which the employment is allowable. Otherwise, it will fall under the provisions of offenses, and they have to face the music of law. That is what I have to state generally. As far as you are not legal professional students, I think a peripheral view will be enough, taking account of the the day in which we are observing. And once again, I am extending my felicitation on the day against child labor, and let you all be any kind of voluntary acts, or to volunteer to bring up these kind of offenses before the general public through social media or any other kind. You are always welcome to these kind of volunteering activities. Thank you.
Thank you so much, sir. Students, if you have any doubts or queries regarding this, you can ask right now. Students, come on, speak up.
Good morning, sir.
Yeah, tell me.
My name is Ashwin, sir. Sir, I have a doubt. If a inspection was conducted at the district level and a child was found a victim of child labor, what will be the further proceedings or legal formalities which should be taken care of?
First thing, it will be reported to CWC, Child Welfare Committee, and they will take the child and they will give protection to the child. Maybe they will be taken the child to any other protection homes. Protection homes are there, and thereafter the offense will be registered under JJ Act. And if any other offenses are there, as per the provisions of law, it will be cited in the FIR. Probably JJ Act will be the offense which is registered by the police, and the initial act we have to be done to be extended from our parties to intimate the matter to Child Welfare Committee. In all districts, there are committees.
Sir, in Kerala, few of the students who go for work at their teenage or adolescence age due to poverty which they're facing in their life. So they will be considering education as their essential need. So for those students, there are certain any kind of exemptions in the law.
That is what I said. If it is for the betterment of their family, helping their own family, it will not be casted as an offense. All other things will be treated as an offense. And moreover, the provisions of Right to Education Act 2009, it provides a duty for the state to provide him all to education to all the children from 6 to 14. So it is the duty of the state to provide their food, provide their other items of the basic needs along with the education. For that specific purpose, this act is enacted. The question you raised is very relevant question, because for the sake of their family, they have to go to work. But now the duty is upon the state to feed their children. That is why they are giving food items and etc. through the school itself.
Thank you, sir.
Yes, yes, I can hear. That is, yes. That is what I said. In India, 1987, a policy regarding child labor was formulated. In all the pieces of legislation, there will be a specific part which says the government shall take necessary steps to implement this and to give propagation. You might be hearing in radio, FM radio itself, in sometimes some glimpses of law against child labor and protection of child rights, etc. So it is a duty of the state to have given to give wide publicity for this. UNICEF is also giving funds for it, and there are specific women and children specific department is also there. You must have come across advertisements in newspapers, full paper advertisements, which, giving the facilities of the children. For example, giving a uchakanyi food, and such situations are there, and food in our and through school, through anganwadis, etc. So it is a duty of the government to extend, to give wide publicity to get the victims aware about their rights. So far as we are also concerned, it is a duty of an NGO. It can be treated that also. However, it is the primary duty, bounden duty. It is a mandatory duty of the government of the state to let the victims aware of their rights.
It was an informative section, sir. Earlier, teachers used to ask us, what is child labor? Then we used to say that a child goes for work at their teenage. But with this webinar, we have been acquired an in-depth knowledge about child labor, their act, provisions, and including child labor committee details too. Now let me welcome Nimmi B. Babu, BCom with computer application, second year student, to deliver the vote of thanks. Nimmi, please.
A child is your heart and not born to push your cart. A child is meant